Hello friends, in this video I'm going to discuss what is the meaning of divorce by mutual consent. Because of any reason, if a couple arrived on a common decision to file a petition for the divorce and terminates marital relationship permanently, then it is known as divorce by mutual consent. In such a case, both the parties approach the court and file petition for divorce with their free consent, and in a given period of time the court gives them the decree of divorce. So in this video I will discuss the concept and procedure of divorce by mutual consent. Let's start with the first question, that is, what is the definition of divorce by mutual consent? As stated in the section 13b(1) of the Hindu Marriage Act 1955, subject to the provisions of this act, a petition for dissolution of marriage by a decree of divorce may be presented to the district court by both the parties to a marriage together, whether such marriage was solemnized before or after the commencement of the Marriage Laws Amendment Act 1976, on the ground that they have been living separately for a period of 1 year or more, that they have not been able to live together, and that they have mutually agreed that the marriage should be dissolved. I can understand this definition is very lengthy and complicated. Therefore, for your convenience, I have simplified this definition into following points. That is, both the parties, that is husband and wife, together may file petition for the dissolution of marriage. Petition should be filed in the district court in which jurisdiction they live, or it can be filed in the district court located near either husband's house or wife's house. The ground must be they have been living separately for a period of 1 year or more and not agreed to live together. The term living separately means not living like a husband and wife. However, it doesn't say anything about the place of living. Hence, they may be living under one roof but not living like a husband and wife. Husband and wife are mutually agreed to dissolve their marital relationship through the divorce. Now, check out what does clause 2 of section 13b say. On the motion of both the parties made earlier than 6 months after the date of the presentation of the petition referred to in subsection 1 and not later than 18 months after the said date. If the petition is not withdrawn in the meantime, the court shall, on being satisfied after hearing the parties and after making such inquiry as it thinks fit, that a marriage has been solemnized and that the averments in the petition are true, pass a decree of divorce declaring the marriage to be dissolved with effect from the date of the decree. Again, I believe this definition is complicated and lengthy, so I have simplified it in the following points. That is, if the petition is not withdrawn in the given period of time, that is between 6 months and 18 months, then the court, after considering the facts and circumstances, passes the decree of divorce, which is effective from the date of decree itself. It means parties need to approach court after the expiry of 6 months from the date of filing the petition, but it must be before the expiry of 18 months from the date of filing the divorce petition by mutual consent for their divorce decree. Here, in case of divorce by mutual consent, The period of 6 to 18 months is interpreted as the period of interregnum, which means the time and opportunity are given to both the parties to reflect their move and take advice from their relatives and friends. However, if they do not change their minds, then they will get the decree of divorce. More importantly, I would like to mention here that the mutual consent should continue until the decree of divorce passed. So if I conclude these two provisions of Hindu Marriage Act, then we find that the parties have been living separately for a period of not less than 1 year. The parties have been given their consent on their own. There should not be any force, coercion, fraud, or undue influence behind the mutual consent. And the parties have failed to withdraw their petition in the given period of time. Now, check out some miscellaneous questions in reference to the divorce by mutual consent. The first question is, what is the procedure of filing the petition for divorce by mutual consent? Following are the steps to file a petition for divorce by mutual consent. A joint petition duly signed by both the parties need to be filed in the respective district court, that is family court. Such divorce petition contains the joint statements of both the parties stating their irreparable differences and inability to live together anymore, and agreement to split the properties and other assets, custody of children, etc. After filing such petition, statements of both the parties are recorded and signed on a written paper before the Honorable Court. After 6 months of this petition, that is period given for the reconciliation, the parties need to reappear for the second motion and final hearing, provided the couple didn't change their mind. After the second hearing, the court passes the decree of divorce, which becomes effective from the same date. Now, the next question is the period of 6 months mandatory? As per the provisions of the Hindu Marriage Act, it is essential, but based on certain cases and the Honorable Supreme Court's instruction, depending upon the case, the period of 6 months may be waived off. However, it is the discretionary power of the court to decide. Now, the next question is, can one party withdraw his or her consent after filing the petition of divorce by mutual consent in the court? When the petition with mutual consent filed in the court and it is under interregnum period or during the transitional period, during this period, both the parties have full right to withdraw his or her consent by filing a separate application before the court. Now, the next question is, what will happen if one party does so? That is, if he or she withdraws his or her consent. In such a case, the Honorable Court wouldn't pass the decree of divorce. Now, the next question you must be thinking is, in such a case, what can the other party do? In such a case, other party is left with two options. That is, either she also withdraw his or her consent and start living together, or to file a fresh petition for the divorce under the provisions of Section 13 of the Hindu Marriage Act 1955. That is normal divorce petition. Now, the next question is, will maintenance be applicable in case of divorce by mutual consent? Definitely, maintenance or alimony is applicable in such case, but it is decided by both the parties with their mutual consent. Now, the next question is, who will take the child custody in case of divorce by mutual consent. Custody of the child is also decided by the mutual consent of husband and wife. So, this is all about the divorce by mutual consent.